And I'm going to tell you now, the incoming president, you will be stuck. Like none of the results. So I'm now going to revoke your bond. Look at me. Are you in this country with or without permission?
Without.
Drinking while driving? And I'm going to tell you now, the incoming president is not very sympathetic with people who are in immigration custody. Do you understand? You will be stuck like Chuck in custody. Tell me, are you a United States citizen?
I'm a resident.
I don't know if you are or not, and quite frankly, I don't care. Are you Arnaldo Bernabe Larios? You were charged with driving while intoxicated. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be afforded to you, sir.
Judge, on October 31st, 2024, officers were dispatched at 2:46 a.m. to report to the motor vehicle sitting in the intersection of a public roadway in Harris County, Texas.
Can I get you slow down just a tad?
Yes,
please.
of course.
Order in the court.
The vehicle was sitting in the intersection of a public roadway in Harris County, Texas, with the driver asleep at the wheel. Upon arrival, officers located defendant's motor vehicle and observed defendant to be the sole occupant of the vehicle. Upon contact with the defendant, officers observed red, glossy eyes, slurred speech, and an odor of alcoholic beverage emitting from the defendant's person, along with poor balance. The defendant admitted to drinking, and an inventory of the vehicle yielded several open, cold to the touch beer cans.
Drinking while driving?
Most of which were mostly empty. SFSTs were conducted. 6 out of 6 HGN plus vertical gaze nystagmus, and 3 out of 4 one-leg stand. The defendant failed to perform the walk and turn because he failed to follow instructions. DICs were read but refused, and a warrant was signed and executed. He has no driver's license, judge, and no prior criminal history.
I would hope that you recognize it's elementary that you're not supposed to have alcohol in the car while you are driving, Mr. Tayun. Do you have a Texas driver's license? Look at me.
No.
Not allowed to drive. What is your immigration status? Are you a United States citizen?
No. No.
Are you in this country with or without permission?
Without.
What happens if you go to jail?
I don't know, I believe they'll return me to my country.
Right.
Cierto.
You will sit in jail waiting for this case to be over with, and then you will be shipped off to immigration. But you will sit in immigration custody for about 6 to 9 months waiting for immigration to do whatever they're going to do. And I'm going to tell you now, the incoming president is not very sympathetic with people who are in immigration custody. Do you understand?
Yes, sir.
I'm putting conditions on you and your bond. And if you violate it in any way, then you will go to jail. The reason you got out as quick as you did is because we gave you a free bond. It will not happen again. You violate conditions. More importantly, if you drive, because I'm ordering you not to, then I'm going to make your bond extremely high. This is a promise that you're going to make to me today, that you're not going to drive. And I don't care what is going on in your life. You drive. I can have a contempt hearing. You will be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. So if you drive 3 times, I will have 3 contempt hearings. You are also not to consume alcohol or illegal drugs. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail. And let me be frank with you. If they charge you with the open container, that is a minimum of 5 days in jail. And I'm going to tell you, if you do anything more than 4 hours in custody, you will be stuck like Chuck in custody with an immigration detainer. Do you understand?
Yes, sir.
Have you come up here swear to us that you're not going to drive? I'm not done yet. After that, you will get to Ramona where you will sign a reset. After that, you'll get with Fleischer for your bond conditions. This is the only warning that you will get from us, Mr. Tayoun. So take it. If not, you will spend a lot of time with us. When you come back, please have a lawyer, sir. Now you may go. Okay, Luis Armando Hernandez Ramos,
Yes, I am.
charged with driving while intoxicated. You were facing up to a year in jail and or a $4,000 fine because of the high blow. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 9th, 2024, officer conducted a traffic stop on the defendant's vehicle at approximately 10:47 p.m. After observing it weave between two lanes and fail to signal lane changes. Upon contact with the defendant's vehicle, the officer observed a strong odor of an alcoholic beverage, red glassy eyes, slow speech, unsteady balance, and a glazed over look. The defendant had inconsistent statements and trouble with the timeline of the evening. The defendant admitted to drinking beer in his truck prior to driving. Standard field sobriety test.
Did he have alcohol in the car while he's driving?
Your Honor, yes, and it's towards the end of the statement. So, officer conducted standard field sobriety test, HGN 6 out of 6, walk and turn 8 out of 8, and one leg stand 3 out of 4. An inventory search of the vehicle revealed 5 empty 32-ounce Corona bottles, one 32-ounce Corona bottle with 1 ounce.
Corona, I'm sorry, can you repeat that?
Oh, pardon.
Go a little bit slower, huh?
Yes, yes. An inventory search of the vehicle revealed 5 empty 32-ounce Corona bottles, one 32-ounce Corona bottle with 1 ounce of fluid in the bottle, and one empty 24-ounce Modelo.
Drinking while driving?
DIC was red, and defendant consented to correct. The results were 0.174 and 0.173.
Mr. Hernandez Ramos, I'm going to find that there's probable cause to go forward with your...
Isn't just jail, it's a chain reaction of legal problems that stack faster than they can be undone.
I'm a resident.
I don't know if you are or not, and quite frankly, I don't care. But one thing I want you to understand is if there is any problem with your immigration paperwork whatsoever, and you go to jail and immigration finds you, they will put an immigration detainer on you, and you will be stuck like Chuck in jail until this case is over with, and then you will be shipped off to immigration where you will sit for another 6 to 9 months. I hope that you would recognize it's damn elementary for you not to have alcohol in the car while you are driving. You now, I am barring you from driving whatsoever. You will be signing an affidavit with me today promising me that you're not going to drive. And I don't care what is going on in your life. If I find that you drive in violation of this affidavit, I can have a hearing to hold you in contempt, slap you with up to 180 days every time you drive.
Yes.
Do you understand?
Yes.
You cannot give any justification at all for getting into a car and driving, and there will be a very hefty toll. I'm also ordering you not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs or unprescribed controlled medication, likewise, you will go to jail. You will not get any more PR bonds. And like I said, any issues with your immigration whatsoever, you will be with me for a long time.
Okay.
I will have you come up here, swear to us that you're not going to drive. I will have you sign a receipt with Victoria. I will also have you sign your bond conditions with Felicia. We will get you out of here because you need a lawyer to represent you, and we will give you time to go hire a lawyer. When you come back, hire a lawyer. If you fail to come back, I will issue a warrant for your arrest.
Yo entonces voy a dar una orden de arresto.
You're charged with 2 cases. You're charged with evading arrest and resisting arrest. You're facing up to a year in jail and or a $4,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 22nd, 2025, at around 7 p.m., officers were dispatched to 1855 Work Road in Houston, Harris County, Texas, in regards to a criminal mischief in progress. Upon arrival, the officers observed the defendant at a location matching the description on the call slip. The officer gave verbal commands for the defendant to lay on the ground and put his hands behind his back. The defendant ignored commands and ran away from the officers. A foot pursuit was initiated, and the officers continued to yell verbal commands for the defendant to stop running. The officers were able to detain the defendant approximately 100 meters away. The defendant then actively resisted, and the officers had to dry stun him. The defendant was using both hands to push off officers in order to avoid detainment. The defendant grabbed the officer's ballistic vest and attempted to push the other officer.
And this is rare. The judge calls out the report itself. No details, no facts, no probable cause. When paperwork collapses, cases collapse with it.
The defendant attempted to push officers multiple times, and the defendant struggled on the ground for approximately 3 minutes before he was detained.
What was he doing wrong? All you said, he matched a call slip. So
Yes, for a criminal mischief in progress, Your Honor.
that's completely conclusory. What is the alleged mischief? What did he do wrong? Who did he do wrong to?
And I don't have that information.
Then none of that? I mean, who's writing the reports? Mickey Mouse? You know? I mean, really? I haven't heard anything. I'm going to find no probable cause. Mr. Gonzalez, be careful, man.
Okay.
When you get into a pissing match with people who have the power of arrest, who's going to win?
I'm gonna be more careful. I promise. It's not gonna happen anymore. I promise. I got my family. I want to,
Okay?
Thank you.
Got it.
God bless you.
Dude. All right. Good morning, Mr. Walker. So, you were charged with failure to identify oneself. That's why you're charged here with us, failure to ID, right? You're facing up to 6 months in jail and or a $2,000 fine. The reason that we're taking you into custody now is because you have 2 felony warrants for, it looks like you were on probation for a felony theft, and they filed, I guess, a motion to revoke because of that warrants issued. So that's why we have you in custody now. I can't let you go because then I would get in trouble. We're going to do probable cause in our case. You have the right to remain silent. Anything you say can and will be used against you. Well, I don't want to talk about the case. You've got a lawyer. You need to talk to him, let him talk to me, because I don't want you to say something that hurts you anymore.
Yeah.
So let's just do probable cause, because I don't know why. I don't even know why we're here.
Yeah, my son, I'm gonna say about the machine, everything. There's no way to put on GPS. Like,
Hold on. Let's do probable
just
cause
straight-
first, because
Okay. GPS.
It's not up to him. We're just talking about these meetings.
I can't. There's nothing I can do on the felony case, man. I'm just a lowly misdemeanor.
In his defense, Judge, the felony motion is based on technicals, and in this new case, this failure to ID.
Really?
Yeah, I don't see anything.
Well, let's do it real quick, and then we can talk, and I can give you more info.
On March 21st, 2025, officers were dispatched to a family disturbance call for service at 2525 Holsworth Road in Spring, Harris County, Texas. which is an apartment complex. The officer began by identifying the defendant, who could not provide a valid driver's license. The defendant verbally identified himself as Adam Mitchell with a date of birth of December 23rd, 1987. The reportee then gave the officers his correct name, and the defendant then admitted to providing false information due to advising about a traffic warrant that he believed he had. The defendant then gave his correct name. The officers discovered an active warrant for the defendant out of Cook County, though there was no extradition.
So there was a warrant out of Cook County.
There was, but there was no extradition.
Cook County, Illinois?
Yeah, sure. I looked at the NCIC. All I saw in there that it could possibly be was some sort of like traffic offense.
Okay.
That's all the trigger he's talking about. Don't say
Not right. So he gives the name of Adam
Mitchell. And Judge, this isn't filed as a fugitive, just a straight alien ID.
Right. Well, because he wasn't. Well, maybe he was. I don't know. Regardless, so Mr. Walker, I'm going to find that there's sufficient probable cause. Well, hold on. I'm going to find that there's sufficient probable cause to go forward in this failure to ID case. It looks like.
Call the police.
I don't want to call the police. They never asked me my name.
I don't.
Like, I'm the person who called the police.
Was this, I thought it was a stop.
No, they
No.
were dispatched to a family disturbance at an apartment complex. The officer arrives, proceeds to try to identify both individuals, began by identifying the defendant, who could not provide a valid driver's license. The defendant then identified himself verbally as Adam Mitchell with the date of birth of December 23rd, 1987.
I mean, I get that you call the police, but nevertheless, I mean, we've got.
Then he told them the right info.
But you still gave the wrong info, and then they looked them up, and then they get, So, I mean, there's enough probable cause to go forward.
Why was that didn't happen, but why did, if I call the police, why are they asking for my ID in the first place? They don't have the right to do that, sir.
They're going there for a disturbance.
Yeah,
They have to, look, I can't get into all that stuff now, but they're going to investigate something that happened. There's a disturbance. They go there. Normally what officers do is they have to look at everybody who's there to determine, hey, who is this? What's going on here? Does this person have any kind of issues? And so, regardless, the good news is that it looks like on your motion to revoke, the only thing is fees that I see in this case. Okay. I can't let you go at this time because this is a felony warrant. You're set at no bond now, but you'll get to felony court on Monday. And at that point, I mean, I'm sure that they'll do something. I'm not going to,
That's crazy, man. I called the police.
I'm not going to.
A couple fighting, and I just called the police. That's all I did, sir. I seen two couples fighting, and I called the police because there was a guy hitting a woman.
I can't give you legal advice.
She's writing everything down too that you're saying. Maybe later
Just
down the
don't
road,
say
you
anything
might
at
want to
this
say
point.
something
You
different.
can talk to Mr. Pons. I'm not putting any conditions on your bond. Just be careful, Mr. Walker. Okay, thanks.
What was our bond in this one? It's PR bond, right?
Yeah, he's got a PR.
No, I bond that for $1,000.
So you're.
That's
Was it
right.
a-
Judge, 6,000.
Excuse me, Your Honor, I'm approaching on Neil White.
Is he?
And Judge, he's been carried since Monday, the 24th. That's when he appeared on your docket initially for a new charge for the bond violation report, which is filed, and also a motion to revoke and raise. But he was still incarcerated on Monday, Judge, Monday morning.
He's right here now, right?
He's here now.
Okay.
But
Come up, Mr. White.
Mr. White.
We're on bond for an assault of a family member.
Yes, sir.
Since 2023.
Yes, sir.
In 2025, in February, you pick up a terroristic threat.
Yes, sir.
And now you've picked up another assault of a family member and a violation of a protective order. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes,
You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 16th, 2025, in Harris County, Texas, officer was dispatched to an apartment for a family assault. Officer met with the complaining witness. The complaining witness had visible injuries on her face, including bruising on her eye and swelling on her head. Complaining witness went over to the defendant's house. Defendant grabbed the complaining witness by the arms and threw her into a table and chairs. Defendant began to punch the complaining witness multiple times in the stomach and slap her in the face. Complaining witness attempted to leave, but the defendant followed her through the apartment complex. The defendant currently has a protective order for terrorist threat, which bars contact between the complainant and the defendant.
Is that the violation of protective order?
Yeah, it's a felony, VPO.
Your Honor, may I be heard? Your Honor, the complaining witness shows up at my client's apartment. He lives there by himself. She shows up like at 5 a.m. in the morning. My client did not assault her in any way. Actually, the complaining witness broke his phone, and my client left the apartment so he wouldn't have to deal with her because she wouldn't go away. But at no time, Your Honor, did he assault her. I did get to check out the videos, Your Honor, where the officers are interviewing the complaining witness. She alleges that he punched her in the abdomen. She is in absolutely no distress, Your Honor, when she's talking to the responding deputies. If he had punched her in the abdomen, Your Honor, I can really say that she probably would be doubled over and would want to go to the hospital. The EMS did check her out, it appears, but she refused transport to the hospital. I couldn't tell from the body-worn cam video, Judge. It wasn't close up enough, but I couldn't tell. I couldn't see any bruises and it's like I said, she was not in distress whatsoever. She is the one who really went to his apartment. He did not violate the protective order. And
The violation of protective order is a felony offense anyways, so.
yes, Judge. Yes, Judge. I understand. I understand.
So I just
And-
have, an assault, a terroristic threat, and now another assault.
Right.
So which assault is he alleging that's the?
Right, Judge.
Right.
Yes, Judge. And she's filed or the state has filed a terroristic threat on her behalf, a charge on her behalf. If she was so terrified of him, Judge, why is she popping up at his
I don't know
apartment?
that that's actually true. Who's saying, he's just telling that to you? I mean, how do we know that's really true?
Well, she's there, Judge. Those are the apartments that are shown on the body-worn cam video. It's his residence.
Is she actually on video at his apartment? Have you
They're
seen
outside
it?
of the apartment. They're outside on FM 1960. That is not her residence. The protective order has got a totally different address where he is prohibited from
Tell me, Sebastian.
going.
Okay, well, the VPO is not based on an address restriction, it's based on the assault of a protected person. And as far as the representations that defense has made today, we have no way of verifying any of that to be true. I disagree with the assertion that she shows no visible injuries. The face does appear to be swollen with some red markings. Number three, the allegation that she's over at the house don't disqualify her as being a protected individual, and VPO is for an assault, not for a residency restriction. And at the end of the day, all those are fact issues. And what we're left with right now is the fact that in 2023, with a separate victim, he has an AFM, bond forfeits, then we have a terroristic threat with someone else, and now he picks up a separate AFM. And we can talk about how she's back all the time, but I think that ignores, first of all, the realities of domestic violence situations. And second of all, this isn't just one person that he's having multiple problems with. These are two separate people. So the state is going to stand on its motion to revoke and raise bail and is going to ask for $20,000.
This is the moment every repeat defendant fears. Courts are patient until they're not. When a judge says the bill comes due, it means leniency just ran out.
Your Honor, may I respond? Sure. The complaining witness has not, recanted to these March 16th to the current charges, to the newer charges.
Which alleged victim is recanting, the first or the second?
The terroristic threat complaining witness, Your Honor. And the other assault family member case, Judge, the complaining witness is currently incarcerated. But
So which one's in jail?
So,
The oldest one in jail.
When?
and
Or,
You know, I'm not sure actually. I had a colleague who spoke to her. I forget exactly which is in for. She is in jail. As far as her recanting, I mean, that's,
is she in jail for something against him?
no, I don't think so.
And also, Judge, the complaining witness, the one that the protective order is on behalf of, she has not given a rip on the terroristic threat case, Judge. So something's not right. She doesn't want to.
Problem is
Tell the truth.
he keeps picking up cases. Stuff keeps happening to him. It's just, I mean, I fall down and I pick up a new case.
Yes, Judge, and I did.
Are we supposed to just let him go because he's picked up now a felony? You know?
I just wanted to relate to you, Your Honor, that my client does not have funds. He paid to get out with his income tax return, Your Honor. He paid to get out on these two new charges. He paid to get his car because he was not arrested at the scene, but he was arrested thereafter while he was driving. They impounded his car. He paid to get his car out. And he paid because to get a new phone or get his phone repaired because complaining witness broke his phone on the date of the alleged incident. And I'm asking the court to leave his bond as is, or in the alternative, Judge, maybe he can borrow some. He's got $250 left from the income tax return. And if you could leave it, or $5,000, he could possibly do that, but not 20. He was in jail for an entire week, Your Honor, when he was arrested for this offense, for these new offenses.
Pick up new cases. That's what happens. I have not asked you to do anything but be safe in my community. You're now working your fourth case. No, I don't want you to say anything. The only thing is that you continue to pick up new cases, and I can't just let you keep doing that without some kind of consequence. No, there has to be consequence to behavior, and the bill comes due. You can't continue to pick up new cases and expect good results. So I'm now going to revoke your bond. It goes with you. I can't. I have to show you that we mean business. Otherwise, we have no teeth. You know, what we say means nothing. I'm going to tell you now that I'm entering an order for protection in all these cases. And if you violate this, I can have a hearing to hold you at zero bond, and I will do it in a heartbeat to protect my city at all cost. If this person comes to you, you don't open the door. If they call you, you don't open the door. Or I'm sorry, you don't answer the phone. If they email you, you don't reply. But at some point, we have to say when. Now's that time. It goes with you.
Yes, Your Honor. Well, my bond.
I'm not going to set it that high. I think that high is obtuse, and that's just, mean-spirited to go that high. But
Judge, this is 2 years worth of history here. Two different people.
That's why they set the felony bond at 30,000. But I mean,
He gave the first victim 10 stitches in the head.
10 stitches in the head.
I read that, Judge.
Tell me about the second one. What happened with the second one?
The second one is this one, and then you want to tell us
How bad are we talking injuries on the second?
Judge, it's swelling and then bruising in the head.
All right, so I'm going to do 10,002 on the first one, 5,000. So 10,003 on the first assault, 5,003 on the terroristic threat, and then I'll leave the second one as is. The new one as is.
Thank you, Judge.
So, no, then that has, no, I need a new one on. Do we need to file a new one?
For the original.
Okay, can you, Sebastian, file a new order for protection on the old case so we can have him sign it? On
Yes,
the
do you want it
2023?
on the two victims or just on the?
No, on both. On both, yeah. Good morning, Miss Alexander. Ma'am, you're charged with the offense of driving while intoxicated. It's elevated to Class A misdemeanor because of the high blow, so you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You are Janae Alexander?
Janaya.
Deny it? So you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
On March 22nd, 2025, an officer responded to a minor craft incident. Upon arrival, the officer met with the wheel witness officer who stated that he was conducting a safety control of a disabled 18-wheeler on the shoulder with his emergency lights activated. That officer stated that he was on the shoulder when he was struck on the driver's side by the defendant's vehicle. After the crash, the officer observed the vehicle to continue to travel southbound. A traffic stop was initiated. The officer made contact with the defendant, the driver, and sole occupant of the vehicle, and immediately detected the strong odor of alcohol upon her breath and slurred speech. The defendant exited the vehicle, and the officer observed unsteady balance. The defendant admitted to consuming alcoholic beverages prior to driving. The affiant officer made contact with the defendant and same signs of intoxication. The defendant stated that she was on her way home from a bar and consumed 1 mixed drink at 9 p.m. The defendant stated she was unaware of when she struck the patrol vehicle. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues observed on the walk-in turn. 2 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were .202 and .201.
Any prior DWI? And
No prior, Judge.
license?
Eligible.
Okay. Ms. Alexander, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? Ma'am, look at me. If I find that you're using, it's not going to go well for you. I'm not asking much from you. If you do not have a valid Texas license and liability insurance in your name, car insurance, you're not allowed to drive. That is also a condition. Do you understand? How old are you, man? You're
23.
Do you have the ability to hire a lawyer? Would you like to apply for a court appointed lawyer?
I don't have, I need one.
Okay. So Deputy Miranda is going to give you an application for an appointed lawyer. I'm going to have you sign a receipt. Victoria will have you take a seat in the jury box while you fill it out. You will meet with pre-trial for your bond conditions, and then I'll have you talk to someone here shortly. Okay? Yes. Are you Victor Ortiz?
No, Judge.
No, this is Osman Rodriguez.
Yes.
Mr. Rodriguez, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 21st, 2025, an officer responded to a two-vehicle accident that occurred near the 5,000 block of Bingle Road. The complainant stated that she had made a right-hand turn northbound on Bingle Road and was already traveling northbound when she was struck on her driver's side by a white van. The complainant identified the defendant as the sole occupant and driver of the striking vehicle. The officer made contact with the defendant and observed red, glossy eyes, the strong odor of alcohol upon his breath, and sweat. The defendant stated he consumed 2 beers, one at work and one in his vehicle as he was driving home. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 2 out of 4 clues on the one-leg stand. 3 out of 8 clues on the walk-in turn. The defendant consented to provide a breath specimen. The results were .160 and .177.
Did they find alcohol in the car? Substantiate that allegation.
Doesn't state in the DIC, Judge.
Does he have a license? And any prior DWIs?
He does not have a driver's license and no prior DWI.
Mr. Rodriguez, I'm going to find that there's sufficient probable cause to go forward with the case. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. That is a condition of your bond. I will have you sign with me today a promise to me that you're going to make. This is an affidavit that I take absolutely serious. I don't care what's going on in your life. I don't care if you have a bunny that needs operating. If I find that you drive, it's going to go well for you. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication, and you will be randomly tested. If I find that you're consuming, likewise, I will revoke your bond, put you in jail. No more PR bonds for you. You have a lawyer. Because you have a lawyer, I will waive your appearance. Mr. Rodriguez, it is your responsibility to stay in touch with him. If Mr. Salinas tells me that he can't get a hold of you because you're playing games, you pick up a new case, you endanger my community, I will put you in jail. For now, I'm going to have you come up here and swear to us that you're not going to drive. I will get you to Victoria. We will have you sign a reset. And then after that, I will get you with pretrial. And then after that, you're free to go. Come on.